UCC Section 3-204 begins with a definition. An endorsement is a signature, but not just any signature. It is not the signature made by the maker of a promissory note. It is not the drawer writing a check. It is not the acceptor of a draft. Instead, it is a signature placed on the instrument afterward, usually on the back, for a completely different legal purpose. According to the statute, an endorsement serves one of three primary functions. First, to negotiate the instrument, meaning to transfer it so another person may become the holder. Second, to restrict payment. For example, writing for deposit only. That limits how the instrument may be used. Third, to assume liability as an endorser. In certain situations, your signature can make you legally responsible if the instrument is dishonored. Here's where many people become surprised. The law focuses less on what you secretly intended and more on what your signature objectively communicates. Even if you never meant to create an endorsement, the signature may legally function as one, unless the surrounding circumstances clearly demonstrate another purpose. In commercial law, clarity often outweighs private intention. Not every signature becomes an endorsement. The law examines several factors. Where was the signature placed? What words accompanied it? What does the instrument itself say? What were the surrounding circumstances? If these factors clearly show another purpose, then the signature is not treated as an endorsement. Sometimes there isn't enough room on the document itself. The UCC solves this by recognizing an attached sheet of paper. Legally, that attached paper becomes part of the instrument. This attachment, commonly called an allonge, allows additional endorsements to continue the chain of negotiation. The statute makes this simple. Whoever makes the endorsement is called the endorser. Depending upon the circumstances, an endorser may acquire rights or obligations simply by placing a signature upon the instrument. Suppose an instrument is transferred merely as collateral. Even then, that endorsement is generally treated as though it were an unrestricted endorsement, at least for determining whether the recipient qualifies as a holder. The law protects negotiability, even while recognizing security interests. Sometimes the instrument identifies a person under a different name, maybe a nickname, a maiden name, or a business name. The holder may endorse using the name written on the instrument, their actual legal name, or both. And in some transactions, banks may require both signatures for additional protection. An endorsement is far more than ink on paper. It determines who may enforce the instrument, who bears potential liability, who becomes the holder, and how commercial transactions continue securely through countless exchanges. Every signature has legal consequences. An endorsement is the legal bridge that connects one holder to the next. It transfers rights, it may create obligations, and it keeps negotiable instruments moving through commerce with certainty and reliability. Understanding the law behind the signature means understanding how trust is carried from one person to another.